Mrs. Chukuma, and as soon as they come, they can okay, yeah. So as soon as she comes, she will come to the table. It's now 10 minutes after 11 o'clock, and I hereby sorry. Okay, sorry.
Good morning, distinguished Rotarians and our friends from the Lagos Multi-Door Courthouse and guests. You are welcome to this mediation workshop, which is being organized between our International District and the Lagos Multi-Door Courthouse. At exactly 11:10 it is my honor to call this meeting to order. Please press the outstanding at the count of 3. Let's recite the Rotary phrase. 1, 2, 3. Oh Lord and giver of all, we praise Thee. May Rotary friends and Rotary ways help us to stand in all our days. Thank you.
I think because this is not strictly meant for Rotarians, because we extended the invitation to non-Rotarians, because we are all part of the human community. Okay, since we didn't, we invited non-Rotarians, we are not going to observe strict Rotary protocols. But we'll try to combine that so that non-Rotarians wants to learn how to do it in Rotary. I think I'll just do a brief introduction of what we're here for, and then I'll hand over the microphone to the trainer. This is essentially geared towards teaching Rotarians and non-Rotarians on act of mediation, because there are a lot of problems in the world, and mediation is one of the nice ways of dispute resolution. So we've gone to the masters to introduce us to the art of mediation, and it's our belief that at the end of the day, we'll all learn one or two skills on how to handle problems. Don't get me wrong, problems are part of human existence, which is the way. So the only thing we can do is to learn how to manage it. The process of managing it can help to minimize it. So without wasting most of our time, I will invite the acting director of Lagos Multi-Door Courthouse to take over the microphone and then run us through the programs. Thank you very much. Okay, I'm called upon to invite Mrs. Chukuma, who is in charge of programs at Lagos Multi-Door Courthouse, to take the microphone and roll the program. Round of applause for her, please.
Good morning, ladies and gentlemen, Chairman, I don't know how it's addressed here. But good morning, everyone. I don't think Rotarian okay got it right. I think my director was just referring to you bringing me to the high table, not to take over the training. So I'm sure they've introduced to you my able acting directors with CEO and the deputy director and head of corporate services of the Lagos Multi-Door Courthouse. We also have Ms. Cynthia Kwesi, please come on. She's the trading coordinator. So we have three of us are here to see how we can help you to understand more about mediation. Thank you. I'll hand the mic to my director now. Thank you.
Thank you very much. Thank you, sir, District Governor. Thank you, Mr. Oki, for having us here today. Grateful. I don't know if you could be projected.
Okay, sorry. Before they took over the microphone, I also want to the chairman of the committee, that is PCW Dispute Prevention and Conflict Solution Committee of the district. And I have some of my committee members here, Rotaractor and Rotaractor. She's somewhere there. Thank you very much for all the beautiful work you've done to make sure that this program comes to life. I formally welcome you all to this workshop, and it's my belief that at the end of this workshop, we will all leave this hall better than we came. So you are highly welcome, and then at this juncture, I hand over the microphone to I think the director of training of the Lagos Multi-Door Courthouse to kickstart the training. Thank you very much.
Thank you very much, sir. Okay, so we've already wasted more than an hour, and we were told that this is a 2-hour program. We have other things to do too. So without any ado at all, I'm going to call upon the director of Multi-Door Courthouse to give us an overview and a few other things concerning mediation. Please, Deborah.
Thank you very much once again. So I understand that we have less than an hour now, so I'll be as impactful as I can be. So the topic has to do with mediation and also resolving disputes. So I just want to have a feel in the house. Who has any understanding of what mediation is, or whether or not you've been in any mediation session before? This is going to be interactive as much as it can be. So if you have any response, you just raise your hand so I don't have to call names. Any? Yes, please.
Well, I haven't been in any mediation. Good morning, everybody. My name is Rotarian from the Rotary Club of Nigeria Globetrotters. I haven't been in any mediation. I am not a legal practitioner, but I have a subtle bias for the rule of law, advocacy, and things like that, which is why I didn't think twice before registering for the training. My understanding of mediation is a subtler approach to dispute resolution. It appears that litigation is always very cumbersome, many a times gives bad blood, and it just sort of creates more enemies instead of learning to understand the perspective that both parties are coming from. So mediation it's a simpler approach to basically solving disputes as against the litigation that everybody's enemy when we come into the courtroom and all of that. That's my understanding.
Thank you. Please can we go to our So I hear something like mediation is a simpler approach, more like the younger sister of arbitration, litigation, something like that. Thank you. I'm seated. Any other person? Any other person? But this camera is on the table. I'm not sure I can move around. Can I? Okay. Because,
No.
okay. So, yes. So I want to move around. Any other person? Okay, yes. There's someone here. Can we have the mic? Oh, you want to speak? Yes, I do. Mic, please. Thank you.
Good morning, yes, everyone. My name is Rotarian from Lagos South, and like she said, interest me that sign up for this. I also signed up because I'm in leadership positions. I just wanted to know more about mediation. So I think I've practiced mediation at one point in my life, my career. And mediation, to my understanding, is just you being a middleman between two people that have issues and trying to bring them to an understanding.
Thank you. That's a good one. Please put your hands together for her. I'm sure even with your children, for those who have children, you have tried to resolve this. I've asked you that several times. Sometimes I'm not able to sign them to settlement of that. Do you understand? So something we do every day. It's part of our lifestyle. A lot of us do not even realize it. But of course, doing it professionally will give you some structure, to doing it well and helping other people. So yes, that's what it is. You have an idea and you are all very correct. To an extent, I'll be taking us through the overview of AGR, Alternative Dispute Resolution, of the Lagos Multi-Door Courthouse where we work, to let you know what we do in relation to resolving disputes. How do you understand? What do you understand by conflict? You understand that conflict is a normal way of life. It's something that happens every day. We can't make it without conflict. So when we have to realize conflict and try to resolve it before it gets out of hand, they will talk about mediation in details, deep dive into what mediation is, the principles of mediation, effective communication skills, and other recommended courses that would let you know about it. Somebody will come up and conclude that part. So overview of AGR. Now, Max Lucado says conflict is inevitable, but combat is optional. Do you agree with that? Conflict was inevitable. You can't do without it. There's a Yoruba balance that says your teeth and home, you won't fight. So how much more human beings? So it's inevitable, but combat is optional. How do you want to deal with it? How you can decide not to, and you can decide to go headlong into it. Now, overview of AGR, alternative dispute resolution is a wide range of dispute resolution processes. Now, alternative dispute resolution, I'll be saying AGR without saying it in full. It's a wide range. There are different things, that you can find in that thing, alternative dispute resolution. The range of processes, techniques that can be used to settle disputes with the help of a neutral third party. My lady there earlier said that yes, with the help of there has to be a third party to resolve that dispute. So that is mediation. With the help of a neutral third party. It also refers to various options people can use to resolve disputes without trial. So when you hear alternative dispute resolution, alternative to what? Alternative to what?
Litigation.
To litigation. Thank you very much. So it's an alternative to litigation. Litigation is what we all know. If any little dispute arises, you say, don't worry, hear from my lawyer. I will go to court. Even if it's a dispute that you should, because you don't even smell at all. So people want to use their power or their ego or their money to show the person that yes, I can deal with you. But does that really worth it? So let's go on. Now I'll be telling you about the different alternative dispute resolution mechanisms we have. That is alternative to mediation. One is negotiation. What's negotiation? Now, does negotiation involve a third party? Anybody? Yes. It does. How? Explain please. Anybody?
Maybe a witness.
A witness?
Yes. A third party.
Yes. Okay, negotiation. Any other person too? So, not necessarily. How do you mean?
Okay, so when you're negotiating and you want to have a mutual agreement, it can be between two people. But when you need the third parties, when you want to have a witness to the mutual terms that both of you have signed. So that's why I said it could be
Okay, okay, so for negotiations, strictly saying negotiations, it's just between two people. When a dispute arises, I will walk up to you, say me and you, let's talk. What exactly is the issue? How can we resolve it? We are negotiating. Okay, but you take 100K. Let me manage the situation. No, I don't have 100K. You think I want to pay. We are negotiating with that person. So negotiation really doesn't involve a third party in the word negotiation. So it's an interactive process between two or more negotiators. So there might be two or more negotiators. Do you understand? Negotiating on behalf of both parties. You know, what do they do? They will seek to find common ground on issues of mutual interest. So their goal is to ensure that, okay, this is in the interest of my client, this is the interest of my client, how do we meet or come to a common ground? So that's negotiation, usually between two parties. By the time you start having a third party, we are talking of mediation, we are talking of arbitration. So I'm going to break this down. Mediation is our focus, but I'll just touch on it a little bit. Mediation is also a dispute resolution process in which a neutral and impartial third party, note the word, the mediator is what? Neutral. He or she has no dealings with both parties before the dispute. Even if you have a dealing with both parties, it's your responsibility to disclose. Let them know that this person, I know this person from where to secondary school, we are both Rotarians, you know, at so place. So, but if you allow me to go on with this mediation, it's fine. So if you allow me to go on as a mediator, I'm fine. But if they say no, I don't want you to mediate this matter because you're already, both of you are Rotarians and you're deciding, you know, taking advantage of the whole process. So, but the key thing about a mediator is that you are supposed to be neutral. So mediation is an alternative solution process in which a neutral and impartial third party is called the mediator. It's invited by the disputing parties. So let's just divide this class into two. This is A and B. So I am the neutral third party in between. I don't know either of you before. I'm neutral and I'm impartial. I'm not interested in whatever you have to give or say. I'm not interested in your status. I'm not interested in the fact that you are the son of the president of Nigeria. You can give me favors. I'm not impartial towards you in any way. So that is what a neutral third party in mediation is meant to do. Do you understand? So it's invited by the parties to facilitate the resolution of dispute by the self-determined agreement of the parties. So the mediator's role is to ensure that both parties come to an agreement. They own the decision. The decision comes from both of them. My job as a mediator is to facilitate discussions between party A and party B. So once I facilitate discussions with both sides, the decisions, those facilitations I go through will come from you. What I'm going to facilitate will come from you. So, but there are skills to learning these things. I just can't come in between and say, party A, you are going to have to leave that out. Let's assume it's a tenancy dispute, for example, and you don't know say it was leave by opposite. I cannot come and tell you that, see, I think you have to leave that house. Make sure you leave the next, right? I leave the next 3 months. It's not my role to do that. I will ask you questions that will make you tell me what works best for you. And so that's where the training is. To be trained as a mediator, they will train you on how to ask those questions without sounding biased or sounding interested in the dispute or showing that you have any dealings whatsoever. So those are the trainings that we cannot do here. So that's about mediation. Now, arbitration is more like what you have in court. Arbitration is adversarial. There's no way you go to court, you have the lawyers representing clients and all that. You have that in arbitration too. In litigation, you have that in arbitration too. In arbitration, you have a neutral third party. What's that neutral third party called? In arbitration, anybody? Sorry? Okay, arbitration is also a process of dispute resolution. It is method where parties submit to a third party called an arbitrator or an arbitral tribunal for the resolution of disputes. So what this works is simple terms that in an arbitration, you know what happens in court? You have a judge. In arbitration, you also have somebody like a judge. But that person is called the arbitrator. You call them a tribunal. If it's they can be 1 and they can be 3. So you have an arbitrator who is like a judge in the court. So in an arbitration, in courts, you have lawyers representing parties on both sides. In arbitration, too, you have lawyers representing parties on both sides. They will argue your case for you. Everything that is done, they will also do it in arbitration. But the difference in arbitration is that you are not booked, you are not wearing legal gown. You are probably sitting over a cup of tea and discussing these issues or arguing your case out. You are in an enclosed environment with your arbitrator, with your registrar sitting, and you hear both sides and take a decision for parties. So what you have in court is a judgment, right? But in arbitration, they don't call it a judgment, they call it an award. So what you have in arbitration is also a dispute resolution mechanism. But everything that happens in court, you have witnesses, you swear, you do everything you do in court. But the judgment is called an award. Do you understand? It's called what? An award. So that's arbitration. I don't want to go into details because there are lots of things to talk about. Then an award. But that's the judgment. That's what it's called. Because it's a carefully written judgment. Like you have a judgment, but it's just that the nomenclature is different. It's an award. That's what it's called. And the arbitrator is not called a judge. It's called an arbitrator or a tribunal. Then you have I said negotiation, arbitration, mediation. And there's conciliation. Conciliation is just like mediation. But the difference is that conciliation, the mediator or the conciliator, the neutral third party, is allowed to give an opinion on its suggestion. That's the difference between conciliation and mediation. Remember, in mediation, you cannot suggest to parties, you cannot say this is what you should do. You can't take a decision for them. The decision will come from the party. But in conciliation, you can give suggestion. How about you do it this way? Have you considered this? You know, when you do this, maybe this is the result that you will get. You can suggest it to parties in conciliation. Because in mediation, you are not allowed to do that. Then you have early mutual evaluation. What this means is that you have a case against somebody. You don't know if you go to court whether you have a chance of succeeding or failing, right? You don't know whether I will win this case or I will lose it. So what do? You get an evaluator to hear your case for you and tell you what your chances are in case you go to court. Do you have a good chance in court? Do you have a good case? Now, these evaluators are mostly retired judges, senior lawyers, you know, who are very well experienced. So they will look at your case. Only you, not on the other side. They will tell you the outcome of your case if you go to court. So what does that do for you? If somebody tells you that your chances are 80% that you will not win this case because of 1, 2, 3 reasons. If you hear that, what's your decision? Will you not go to court again? Because he has given you an informed decision. You can make an informed decision by yourself and decide that I don't want to go ahead with this. I want to resolve with my neighbor. Okay, I don't have a chance. Better go and settle this amicably so that you don't be blown out of proportion. So that's what early mutual evaluation does. You evaluate your case early before you take a step on what dispute resolution method to go into. So that's just the simple terms of that. And then you have hybrid processes. Hybrid is neither here nor there, or combination of this and that. Do you understand? So you can say that when a dispute arises, I want to start with mediation first. If at the end of the day I'm not able to resolve, I want somebody to take a decision for me, for us in that mediation. Two parties will have agreed, but it's not something that one party can do again. So hybrid can be med EME, mediation. It can be a combination of a lot of these processes. So it just simply means that it's meant that I want to go to mediation. If you don't resolve, because not every case that gets resolved in mediation, let us get an arbitrator to take a decision for us in this matter. So it moves into arbitration. So whatever decision that you take, or it can be argument in the course of arbitration, but there's always something about the arbitrator telling parties that in case you want to settle, the door is open. Do you understand? You can go and discuss. If you have an agreement, bring it so you can enter it as consent award. And you don't have to go through the process of hearing witnesses and all that. So whatever agreement you reach will be entered as consent award. And then they go the arbitrator. So that is that about. So now let me tell you a bit about the Lagos Multi-Door Court concept. Our office is the Lagos Multi-Door Courthouse. I don't know, but when you hear about the Lagos Multi-Door, what comes to your mind? Sorry? For the first time. You said it before. I know. You know. You want to do? Oh, okay, okay.
I work with judicial probation.
Oh, okay, good. Any other person? So when you hear of multi-door courthouse, what does it say?
Like many options.
Good.
A court with many options.
Yes, it's many doors. So as I'm in this room, I can see, let us assume all these windows are doors. I can see one door, another door, another door, another door. So when I have a dispute, I can decide which door that I want to go to. Do I want to go to arbitration? Maybe my case does not warrant arbitration. Let me see which other door. Oh, mediation might be best for me. Or someone might say, no, why don't you do any door? Do you understand? So you have options and you choose which door best suits your dispute. It's not every dispute that should go to court. Do you agree with me?
Yes.
It's not every dispute that should go to court. And some cases in court that have no business being in court. And they're in court because of ego. Because somebody has power that the other person. Someone wants to deal with somebody. Or somebody has no understanding that this case should actually not be in court. Do you understand? Some people is out of ignorance, they don't know any other way. So it's not every case that should go to court. And it's not every case that should go to mediation either. For example, I heard that there's one bulldozer come, they want to come and bulldoze my house down the road. What is the mediation the first place I should go to? Before I even get to the door, the house is down, and then I'll have no recourse to anything again. What should I do? I want to court with this kind of cases. Because an injunction. Please let them stop this thing first before we go start, because if they don't stop it, there's nothing to even discuss. So mindful that that's the concept, and this concept of multi-door came from somebody, Frank E. Sanders. He's a renowned professor at Harvard Law School and was one who pioneered the idea of the multi-door courthouse concept. It's a concept. That concept of the multi-door courthouse is a concept standard in which you have access to justice through different doors and not just through one door. It should just be litigation. So that is why we came up with the multi-door courthouse. We came up with the multi-door courthouse concept. And in Nigeria, in fact, in Africa, the Lagos Multi-Door Courthouse is the first court-connected legal center to have a multi-door courthouse. I think we should plan for this. Okay, so that is the idea, the concept of it. So we have negotiation, mediation, arbitration, and all that things. Now, NMDC, like I said, was the first court-connected ADR center. But when it started as it was established on 2002. By the way, we'll be 25 years next year. So for those of you that don't know what to come to your house, I'm going to show you our course. Do you understand? So it was started in 2002, and